Welcome to podcast time at Stuart Miller. I've got a wonderful guest for you today. I've got Mr. Paul Turner. Paul, over to you. Tell us about yourself.
Thank you very much. Thank you very much for inviting me. It's a pleasure to be here. I'm Paul Turner. I'm an immigration barrister. I've been practicing immigration law for 25 years.
You're also a TikTok superstar. That's where I got your details from.
Yes, when I'm not in court representing people, I'm in front of the camera trying to explain immigration law, trying to make it more accessible to people.
Your journey into law. Why law and then why immigration?
Well, I've always been interested in history, and it came a point in my life where I got to a bit of a crossroads. I was living in Brighton. I was having quite an easy time of it. And a friend of mine said, you need to grow up, take a proper job. So I thought it's either history or law. And I thought law, living history. So I chose law.
And then why immigration law?
At university, I did a course on immigration and nationality. And then when I was looking for work, I think, to be honest, immigration chose me. It was the thing that where I got my first job offer, and I fell into it and then have loved it and have been doing it for the last 26 years.
So I've got to ask, and please don't take it personally, white man doing immigration law, telling people, come here, I can help you stay. I mean, does it fit right?
I think it fits with what it is to be British. I mean, the British went around the entire world telling them that it was the best country in the world, blow learn English. And for me, I think it's about openness. It's about that this country is built on immigration. It's built on whether it be the Romans, whether it be Irish, whether it be Germans, whether it be French, Chinese, Jews. It's a country that's built on immigration.
Remember the Indian subcontinent as well, yeah?
I was going to say, I find it offensive that we draw a line that when it comes to colour. I think that a lot of immigration law, and this I find offensive, is colour-based.
Yeah.
And I think what we have is a system whereby if you're white, say from Australia, New Zealand, South Africa, then immigration isn't a problem. And a lot of the immigration laws over the last 100 years are not really designed in respect of numbers. They're designed in respect of colour.
Yeah. I'm glad you said that, because if I said it, people will tell me you don't know what you're talking about, but clearly your counsel, many years experience, and it's based on your experiences of life. Are there any changes you'd like to see in the way the country, the legal system, perceives people in relation to immigration issues?
Immigration is a dirty word in the media, and I would like it to be whether that's a systematic or an overall issue. I'd like it to be more the migrants that come to this country generally contribute economically as well as culturally to the richness of the UK society. I think that would be the big thing, is that I would like migration to be seen as more of a positive.
So what changes would you want to the system then?
Changes to the immigration system. If we look at the Home Office, I would like the Home Office to be more efficient, more client-centred. I would like them to be a lot faster in the way that they give cases.
Absolutely.
Because I think if I was to say the big change for the Home Office would be speed in processing cases. Because at the moment, big clients can be waiting 2 or 3 years for a decision.
Yeah. Also, the thing with me is again, dealing with people from a criminal perspective, when you're taking instructions, a lot of people have been here for a substantial period of time. They have no means, safe to say they're street dependent, and they're stealing literally to live. And from my view, if I get it, you're not allowed to work, get any form of meaningful work or employment. But if that restriction can be lifted, these are able people I represent, electricians, gas engineers, construction workers, who can contribute to society whilst the case is pending and pay their taxes, of course, and then not be in the criminal justice system.
And we look at the asylum hotels and the amount of money that's spent on it. And I do question whether if the individuals were waiting or given the right to work, whether they would be staying in these hotels or whether they would be moving into the community, and as you say, paying taxes, and also dispelling some of the myths about asylum seekers just coming for the benefits. Because anybody that's dealt with the benefit system knows that we're not going, no one's going to travel 7,000 miles to get £35 a week.
I mean, it's off the grid now, the amount of people that come into the United Kingdom. But once they're here, because there's nothing for them, they get into a negative environment. Homelessness often leads to other rough sleepers, often leads to drug dependency, alcohol abuse, mental health issues. And then unfortunately, it's a drain on the system. Whereas if the system actually dealt with them correctly in the first place, as you correctly pointed out, previously it was 6 months, ask for the restriction to be removed, and then you could get some form of meaningful employment and contribute towards society. But that's the void there.
Alternatively, if you processed all the claims within 6 months, and the people that were entitled to be in the United Kingdom were then granted visas so that they could live and build a life in the United Kingdom, and resources were spent on removing the people that weren't in the United Kingdom, then that, I think, would have a better impact on the public perception of immigration, because the people that are here lawfully and are contributing, and the people that shouldn't be here are removed from the United Kingdom. So the migrants that are here, supposed to be here. The migrants that are not supposed to be here have all been sent on.
Have you seen a shift in the way the courts approach cases over the course of your career?
Yes, I have seen. I see the courts become more sympathetic towards, far more sympathetic towards cases that involve mental health issues, cases that involve vulnerable women, cases that involve minors. I've seen the law develop to be more, to use the word, hands-on. And whereas before, back to 2000, 2002, the appeals could be quite rough and ready. Now there's a lot more protection for the vulnerable.
I think when you say that, a lot of the judges are more, how can I say, counsel, solicitors who have now progressed onto being judges. So they've got the kind of grounded work experience of litigation when it comes to it, as opposed to the old hardened tribunal judge sitting there who's probably got 30 years of experience dating from the 70s to the 2000s, but no hand-on experience in relation to what really happens on the factory floor. That's probably why. Have you ever faced challenges with interpreters or translations affecting a client's case? Basically, the dodgy interpreter.
I have had that, and I've had I've been in court, and the interpreter is interpreting for my client, and on at least 3 or 4 occasions, the judge has stopped the interpreter, asked the interpreter to reinterpret, because the judge understands the language of the appellant, and the judge has said to the interpreter, "You're not actually accurately translating." And my concern is that if that's happening in the 1 or 2 or 3 or 4 cases I've seen where the interpreter speaks the same language as the judge, if the judge didn't understand what the interpreter was saying, what the client was saying, then there's a very real risk that the client's case is not being translated properly. And I've seen it where the client will talk for, say, 15 or 20 seconds, and then the interpreter will go, yes.
One word answer. Like you say, the judge has been blessed with speaking another language. Like myself, in court, I can speak fluent Pashto, and client speaks for at least 30 seconds and the answer's no. And look, that's not what you said. Could you explain? And it's to the point as if the interpreter is saying, you're challenging my credibility or integrity. And I said, well, he didn't say no because I speak fluent language myself. So could you translate properly? And the judge has to get involved, saying, look, he's not picking on you. Could you just do it properly? And it does lead to miscarriages of justice.
Sometimes I've seen interpreters where they don't seem to like the client either.
No.
See, they're quite, they feel like the leads are better than the client, or they don't want to be with the client. Whereas I'm quite comfortable doing it. I'm doing it, as you have for many years. But I see other people that are not comfortable with it. And then, you were talking about the type of client I get. Often I will have clients that come to me having lost the case, and I look at the case, I think, this case is really good. I go, what happened in court? And something that you may have heard is when a client say, well, my lawyer didn't say anything. And I'm like, what? They said, he just sat there. I'm like, he didn't interrupt. He didn't put your, no, he said about 10 words and we were done in half an hour. And I'm thinking, this is a 2-hour case. And there was lots to say.
There may be a cultural misunderstanding on the person who's making the application, but do you not think it's obligatory upon the person making the application to understand our culture? Or do we just have to understand their culture? I mean, we're accommodating. We're accommodating.
I know. And without sort of sliding down the Nigel Farage, I think it's I think it depends on who the applicant is. If the applicant is somebody that doesn't have any particular impediment, whether that's mental or physical,
Yeah.
then I think that there's the obligation on them to make the application and to understand a bit more of the cultural relevance and the significance. If the person comes from a culture where they have been oppressed, say, I'll take Afghan women, for example, and Afghan women probably aren't at the moment very good at speaking out or advocating for themselves. So I think that given that the Home Office ought to be aware of where they're coming from, literally and culturally, they can and should make more allowances. If you have two people, one's the Afghan woman from a small village in Helmand, and the other one is an Afghan doctor that's been working with American forces. The Afghan doctor, I would say, has to adjust, whereas the woman allowances ought to be made for her. So I don't think there's a one-size-fits-all answer to that. And again, it goes a little bit beyond your area of work and mine. But if we think of, say, Iraq or Libya, for example, Western adventurism, we're going to go in there and we're going to get rid of this. We're going to change everything for the best. And then it's not the best. And then the people then leave the war-torn country, come here, and we can't remove them back. And then it demonizes everybody else. See, this is relevant with Iran at the moment. Everyone's talking big that, well, we're going to do this and it will be regime change. And I'm thinking, we haven't really done very well with regime change recently.
No, history dictates, it speaks for itself. Any attempt to deal with regime change has massively messed up the system. We haven't recovered. It is what it is.
What you will also get is huge amounts of migration to the UK.
Because Trump's already signed an executive order. Nobody's coming to my country. He's got the banned list. People from certain countries, you're not coming to my place. My doors are closed.
It's easy for him because he's 1,000 miles away. They can walk pretty much through to Europe.
And they have done so, and that's what people do. Okay. Immigration is really at the headlines. Do you think media coverage has impacted on your work?
Yes, I think it probably has. It's on a personal level, it's made me more determined to do the best possible job. It's impacted me in a certain way, which is if I bring up my work in a social setting and I describe what I'm doing, I can immediately tell whether the people are kind of fairly liberal minded or whether they think that I'm subverting the UK's economy. But again, it's given me an opportunity, both through my own channels and through the national media, to actually try and put the other side.
I mean, we touched on it earlier on and you raised it again. Do you actively tell people you're an immigration lawyer?
In a social setting, no. Because if I don't know the people, then no. And it's not that I'm ashamed of it, but sometimes I think if I'm going out for the evening, I don't really want an argument when they start trotting out all the reform nonsense and misconceptions. What was it? Someone said if you argue with a fool, you become a fool.
Yeah, absolutely. But what I meant by that was clearly you're a barrister, and it's very hard to come by, and it's a prestigious title to have, being a barrister, being caught on the bar. People must say, what kind of barrister are you? Do you show any degree of apprehension, or do you?
If they've asked me, generally I won't tell them what I do. If they ask me and say a barrister, what type of work? I usually say, I'll usually say immigration, but somebody quite close to me says, oh no, civil liberties. And I'm like, no, it's immigration. I represent I can say I'm a human rights lawyer, but they're the human rights of migrants. So then I'll come out and I'll just be combative.
Somebody who's a British citizen now, or alternatively got indefinite leave to remain, commits a heinous offence, sexual offence, murder, drug trafficking, people trafficking, whatever. How do you feel about defending those kind of people to stay here?
I feel like I'm doing my job. And I have to, that's where I rely on the years of professionalism, because if I was given a choice, I would rather have people that are victims rather than people that have victimized other people. I live in this country and I don't like to see crime. I've been a victim of crime. But I am able to distance my personal side, which is to then looking at the rights of the individual, potentially And I think where do I manage to find the passion to defend it is by looking at the impact of, say, family members if the person's being removed. Because the individual themselves may have not many positive qualities at all.
But again, as you point out, everybody's got a right.
And I have all of the people, all of the criteria that you've talked about. I have represented people and I have won cases in that regard. I have cases on the face of it. I read the papers and my client had killed somebody. And I looked at it and I thought there wasn't a reason for it. And if you just read the refusal letter, you'd say, well, he should just be removed. But when I dug into it, the person had really profound mental health issues and really was not really aware of what was going on either at the time of the offence, at the time of the hearing, or any time thereafter. And if he'd been removed to the United Kingdom, then his life would have been short and miserable. So in that case, I think he actually, as all clients, it was important to just focus on the fact that you needed to look beyond the offence and look at the consequences of removing him. And the court agreed with me. I was pleased with it. I'd like to say the client was pleased, but I don't think he realised.
And again, a tip to the litigator. It's not just a mere assertion by the person saying, or his party friends per se, saying that there's mental health issues. Proper reports have to be tendered, country guidance reports, family statements, anything from social services. So you assisted somebody from being deported from the United Kingdom. He raised mental health issues. Now, this is a point for the litigator. It's not just a mere assertion. You need proper mental health reports, a history before the court, statement from family members, anything from social services, reports from the prison he was incarcerated in, and anybody else who can assist in making the application. So when it goes before the tribunal, you've got a proper folder, a proper pack to make your submissions with, backed up by factual information.
I mean, I can't support that enough. I mean, but a case in court, then the burden is always on the person that's bringing the case. So, for example, in the case where the client had significant mental health issues, it was necessary to get all of the NHS medical evidence relating only from the GP, but relating to his hospitalisations and also directly from the psychiatrist. Now, this material on its own simply wasn't good enough because this material indicated that my client had suffered from these issues. It was then necessary to get an expert report to take what the NHS said and put it in the context of a report that was designed for immigration purposes. Then it was necessary to look at the country to which the Home Office was sending him to show that he wasn't going to receive the appropriate treatment if he was removed to that country. Vague assertions, a couple of letters from the GP, they're not going to get anyone anywhere. So again, to any litigator, if somebody raises mental health, or alternatively, and this is something I would say, as a practitioner, you may have come across this. I've had clients that present and I say, have you got any health issues? And they say no, that the manner in which they are talking, speaking, indicates that they clearly have. Then they can get the help which helps them mentally and helps their health.
You see your client. I'm in court on a daily basis, dealing with the most vulnerable. And when you ask somebody a question, are there any alcohol issues and they're shaking? No. Are there any drug issues and they've got little kind of skinny needles up and down the arms? No. Are there any mental health issues? No. And then you can identify, look, hold on, there's something going wrong here. You need to refer them on to relevant agencies and they can assist, contact family members to make it substantive. So you've got to be proactive in a defense. Okay, let's move on from there. Now, controversial topic. Shamima Begum. And you're going to laugh. Your views, should she be allowed back in or not? And before you say anything, my view was, before I actually read into it and understood the law back then, and then modern day slavery, exploitation, was no. But when I actually read into the case, taking on board her age, her vulnerability, how she was brainwashed here, only for her to go abroad, and the way she's been dealt with, it's yes. So over to you.
I've gone the other way. I used to think that perhaps she should be allowed back. But my view is stepping away from the personality side and looking at the risk side. What, and I've read the cases on a number of occasions. It's awful what happened to recruiting, and then it's appalling what's happened to her, the sexual abuse that it seems to be that she underwent when she went. But the way that the country has to approach it on whether she presents a risk, and if they conclude that she presents a risk, then I think that they're entitled to say no. And that's without looking at her character. Her character has been so distorted by what she has gone through, either as a victim or what she has gone through with a modicum of agency of herself. And as a result, she poses a risk. Then I think that just about on balance, the answer is no. And I suppose the example, an analogy, and this isn't a perfect analogy, but if I was removed to illegally to, say, Corsica, and I caught the plague in Corsica, would that entitle me to be removed back to the United Kingdom? Because I was removed illegally and I caught something which I could pass on to other people that I have no control over. Am I a danger to other people?
You see, Paul, again, I disagree with you. And the reason why I disagree with you is because clearly any attempt for it to come back has to be through the SIAC provision, the Secret Immigration Appeals Committee. I think that's right, isn't it? And how that works is you get some lead King's Counsel who you only get to see once, but you'll never see again, I think it is. And any information tendered to them, they can't even disclose to you. And therefore, how are you to probe or kind of look at the evidence to question it in the first place? So is that really fair? If that's because remember, the government's acting on intelligence, and the analogy you gave was a plague. How do we know this lady's been so far contaminated that when she comes back, she'll pose that risk to national security?
I mean, I'll touch upon SIAC. In respect to that, it's really, the question is, I don't know. And so that's why I have huge amounts of sympathy. And because I don't know, I choose to place my trust in the
system,
the courts placed in it. I don't feel comfortable with it, and I see it, but without knowing it all, and this touches upon the SIAC issue, without knowing it all, how much do we trust that she has had a fair crack of the whip and the decision is correct? If the decision is correct that the assessment that she poses a risk is a fair assessment, then it's a fair decision. It's a profoundly disturbing decision, and I think that it would be fair to say that. What I think is, I think that perhaps they shouldn't make an example out of her, because I do think that they demonized her in the way that they've treated her, and I think that perhaps if they hadn't demonized her, then things would be different. But I had sympathy.
Just briefly touching upon this, and we're going to move on. What are some of the most damaging myths or assumptions you hear about immigration cases?
Damaging. All asylum seekers are coming here, they're taking our jobs, they're taking our benefits. You can't get a doctor's appointment because there's an asylum seeker. I think that would be it, that they're swamping the country, there's an invasion of migrants. Migrants are invading, public sector can't cope, they're taking all our houses, they're getting all our jobs. I suppose the one that I get is that migrants get preferable treatment over British citizens. I suppose it's one of the myths it's an attractive myth, isn't it? You want to kind of, they come over here and they just get looked after.
I think people just want to pick on the vulnerable, isn't it? At the end of the day, it's like, who can we pick on? The vulnerable. They can't fight back, so let's just pick on them, and it's a done deed. Like a done vote. Vote. Let's just pick on them. Okay, fine. Right. Can you explain how a criminal conviction can affect someone's immigration status even after serving their sentence? General, say you've got indefinite leave to remain. You've not stabilised your status. You haven't got British citizenship. You get a conviction. I think it's 12 months or more. It's 12 months, isn't it? Yeah. Okay. That's it. Finished. notice of deportation can be served upon you.
It can be. Now, what I would say, and this is just to go to anybody that has indefinite leave to remain, anyone that's had indefinite leave to remain for more than 12 months, do yourself a favour, and if you qualify for British citizenship, take it.
Yeah.
A number of clients I have that have had indefinite leave to remain for 5 years, and then they get involved in something, and then they find themselves facing removal,
Yeah.
and their entire families here, whereas somebody that has acquired British citizenship that's done far worse isn't facing this problem. That's the first point. Second point is, when you're above 12 months, then the Home Office can make a decision as to whether to revoke indefinite leave to remain, but they will usually send out a letter saying, we are minded to revoke the indefinite leave to remain. Can you tell us why we shouldn't do it? Now, it is vital at that point that the person who receives that letter gets in touch with a lawyer immediately to put forward reasons as to why their indefinite leave to remain should not be revoked. That can relate to the nature of the offence, the nature of the sentence, and the nature of any reasons why that person should be allowed to stay in the United Kingdom, family, health. But if somebody has it and they think, I need to explain all the reasons why the Home Office shouldn't take my permission to stay with me, it's too much for me, I'm in prison, I'm really scared. If they contact me or they contact another lawyer, we are always able to write to the Home Office and say, look, my client's in this position.
Yeah.
I'm going to need 14 days, 28 days, 42 days to provide reasons why. And the court have considered this, and the court would allow, and the Home Office have accepted it in their guidance. So it is a lot easier to prevent the Home Office from making a decision than trying to rectify after it's
Yeah.
done.
Yeah. Have you represented clients facing deportation following a criminal conviction? And what stands out in those cases?
I've had people convicted of everything from drink driving offences to murder. And what stands out from it, and this is really important, it is the effort that the Home Office put into removing these individuals. But if it's a conviction, if it's any conviction over, say, 2 or 3 months in prison, I find that the Home Office will throw the book at the individual.
You've now been deported. You have been deported. You've not left voluntarily.
So my nights, I hope.
And you attempt to come back into the United Kingdom. Are there any time bars on you?
There are 2 things to take out of it. Some clients will re-enter the country illegally, deported on Monday, and they'll be back on Thursday. And then they'll make another application. They're entitled to do that, but they ought to be aware of the fact that if they do enter illegally, then when the next decision maker looks at the case, the decision maker will think they didn't really take the UK law seriously. That doesn't mean to say they will lose. If the case is a compelling case, they can still win. For people that have been removed, there are something you can apply for what's called revocation of a deportation order. You can do it as a standalone application, or you can make an application for entry clearance at any time.
Yeah.
If you make a standalone application for revocation, you may not get a right of appeal. But if you make it as a spouse application, then you will get a right of appeal. So I think to your next question.
Yeah. It's something I saw in court the other day. Somebody who'd been deported from the United Kingdom and entered illegally and was charged with a criminal offence, breaching UK immigration law. And I think it's up to 5 years in custody. So if you do enter illegally and you've been deported, you potentially, if the Home Office think it's appropriate to do so, can face criminal sanctions.
Yes, I mean, there are some countries where people enter the United Kingdom and they're quite relaxed about coming back in, and it's quite easy, contrary to what the government says, to re-enter the UK legally. But people ought to be aware of the fact that, like your part, if they're caught, then that can lead to a separate charge, conviction, and another prison sentence, and another trip back home.
It used to be the case that you could be in the United Kingdom for 14 years, unbroken stay it was, and then you could apply for status. It's now 20 years, I think it is. Yes. What do you need to provide or show to the tribunal when making an application to the Home Office, not tribunal, sorry. What do you need to show to the Home Office when making such an application?
Right. For the 20-year route, which will lead to a 2.5-year visa, it is necessary to show that it's more likely than not that you've been in the United Kingdom for 20 years. You could get a copy of your medical records, bank statements, phone bills, utility bills, pay slips if you were in the United Kingdom or you were working illegally, that the Home Office will still consider them and they won't penalise you even if you weren't working with permission. I've had clients who were working in a different identity for 7 years, and they've used the work that they did in the different identity as proof they've been in the United Kingdom, which might sound strange, but in this area, it is their physical presence in the United Kingdom. So any evidence. Of course, the problem is that following Theresa May and the hostile environment in 2012, clients can't rent, they can't work legally, and they can't drive. So if you have friends that have known you for that length of time, get a statement from them, anything at all.
The national referral mechanism, getting the reasonable grounds and then the conclusive grounds. Does it actually work? In criminal cases, it can't actually be tendered in evidence in certain offences. Is it tendered in evidence in immigration cases?
Yes, and I would say it actually does work. And often the competent authority, the NRM, decision will make the difference. And the decision-making process seems to be quite thorough and quite sensitive to people's needs. I've had both men and women that where the Home Office or the competent authority has found that there's a conclusive grounds finding of, say, slavery.
Yeah.
Often, a positive conclusive grounds decision coupled with medical evidence, if it's relevant, is all that's needed for an appeal to succeed. So it's important if somebody comes into my office and I ask open-ended questions to get a feel for them, if it appears that they've been the victim of trafficking or slavery, to send them to the competent authority as their first port of call. I would encourage anybody to do that. I didn't know you couldn't rely on it in criminal cases.
No, you can't. It's adduced. It's if you make a referral to the national referral mechanism, usually by way of the first responder, usually the police officer investigating it, and you get conclusive grounds, 9 times out of 10 that CPS will probably withdraw it, subject to the allegation. But in terms of whether or not it's adduced in criminal cases, again, it's a grey area. No, at the Court of Appeal, you can, of course, but not for whatever reason. Anyway, moving on for that. Hot topic. Marriage abroad. Somebody in their wisdom decides to get married abroad and they bring their partner here. An application is made for the spouse to come to the United Kingdom based upon a person presently settled in the United Kingdom. And that relationship, unfortunately, goes to pot. What can a person do to get their partner removed, if at all?
Well, so am I now the person that wants to remove my my migrant?
Yes.
I tell you what some clients of mine have done and what I'm aware of. Which is not improper. If the relationship breaks down and you could notify the Home Office immediately. My husband, who is a migrant, or my wife, who is a migrant, who entered on this day, who this date of birth and with this visa number and copy of the passport, is no longer in a relationship with me. The relationship has broken down irretrievably. We are no longer there. That's about the limit of it without sounding like you're insane or you're out for revenge. The Home Office may well find the notification, see the letter, and then they will probably curtail, if they're active, curtail the person's visa. It is important, though, and I've got to say this, that if you're thinking of writing to say that the relationship's broken down with your wife, husband, etc., it needs to have properly been broken down. The number of cases where they've obviously had a bad argument, they've had a row, or they've spilled the tea on the bed or something, or fed the dog, and they've written to the Home Office saying the relationship's over, and then the Home Office have then 2 months later written to my client saying your visa's coming to an end, by which time they've got back together.
Yeah.
In which case, all you're going to do is you're going to end up spending thousands and thousands of pounds on an uncertain legal process, and then I would have to go to court and say, I've got a bit of temper. I didn't really mean it. We're really happy. And then, of course, in the back of the mind of the judge may be thinking, is my wife like controlling me? Is there some sort of issue is, are they really back together, or is he only saying that because he's scared? So if the relationship's over, by all means tell the Home Office. If it's a bad argument, they just sleep on it for a few nights before you can.
But again, there is actually a Home Office link, which if you Google and put in the correct words, it'll come up and it's actually obligatory upon you to report in the first place, because and you've got to notify the Home Office. But the consequences of doing so, as you say, are dire. So if it's just a minor argument, get on with it and move on. Second to that is, unfortunately, relationships do fall apart, and a lot of people think, and the amount of calls we get is unprecedented on this point, is that stay on the grounds of domestic violence. How does that work?
Domestic violence is a concession whereby if I am the spouse of a British citizen, and the British citizen I'm the victim of domestic violence, I can apply immediately for indefinite leave to remain. I don't have to stay in the relationship. The law is quite clear. The courts are quite sympathetic. I don't have to endure the abuse just for the visa. And I can make an application for domestic violence under the immigration rules, and I will get indefinite leave to remain, and I will not have to be with the person. On a personal level, if somebody is the victim of domestic violence, they should not suffer in silence. They should not allow themselves to be abused in any way. They should get help immediately. So, and I know there's a tension here, because people that have undergone abuse or come from a culture where they're not used to complaining, they don't go in.
Yeah.
So it is difficult, but there are agencies and organizations, you'll find them online, that will help people register the fact that they're victims. And then the process is fairly easy.
Okay. Say, for example, there is no domestic violence. I just don't get on with you no more. I'm sorry. I just want to go my way. You go your way. But I'm a guest in this country based upon the fact that you brought me to the country as your applicant. I'm waiting for some form of stabilized status. And you don't want to be with me no more. But we have children. Do I have to go back?
If you have children then, and the person is present and settled, then the children will be British citizens. And the answer is no. And the immigration rules reflect this. So you would need to show that you continue to play a part in your children's life, but you will not need to go back. And again, I would say that the moment the relationship irretrievably breaks down, you might have 2 years left on your spouse, but you think, do anything now, I just wait. But you're living in the country, not honestly, that the appropriate thing to do is to say, right, we're now divorced, and now I continue to see my children and play a role in their part. I'm going to make an application based upon that. And the Home Office will grant it. It's better you do it sooner rather than you try to leave it for several years. And then the Home Office will then say, well, why didn't you do that earlier? There's one type that a Part D might be. Suppose we're in a relationship and we just don't get on it. No children, and both people are alive, no domestic violence. What I would say in those situations, the Home Office would expect you to go home. They would say, well, you came over here as the partner, you haven't had any kids, it's just not worked out. The Home Office will give you a period of time to regularise your status. If you're in a relationship which is broken down through no fault of either party, and at some point it's going to come to an end, you'll either need to go home or find another reason under immigration rules to stay. And you should do it as quickly as possible rather than waiting until your visa runs out.
Just coming back on another point then, if you're convicted of a sexual offence, and there was a press release recently where they're saying automatically you can't stay in the United Kingdom. What grounds does that have on Article 3? And also, in as far as that's concerned, do you think that'll come to fruition? Or is it just debate, vote winner, innuendo?
I think it will come to fruition. What the Home Office or the government is saying is that if you're convicted of any sexual offence, you'll be excluded from refugee status.
Yeah.
Now, without making excuses for people that are convicted of sexual offences, does that mean that they're all going to be put on a plane back to a country where they would be at risk? The answer is probably no, because if their life is at risk of torture or inhuman or degrading treatment, which will be the same criteria as refugee status, then the Home Office faces an absolute ban on removing them. So what I would say to this is just publicity. This is just feeding the reformed dog. Because the person will be convicted of a terrible offence. No, they can't be a refugee, but no, they can't be removed.
Okay. Putting the refugee to one side and including the British citizen. I think there's a recent case before the immigration courts at the moment for deportation of certain individuals convicted of sexual offences. And they're still here, decades after the conviction. And that falls hand in hand with what you just said, in terms of the fact that, yes, they can do it, but it's going to be very difficult to do because of human rights violations with the host country, or alternatively, they're not willing to go back or even accept them.
I'm sure you'll find it quite shocking that I think it was the Bradford gang where I think a couple of them have been deported. Others were British citizens and in their national
revoked.
Often. And then they were clearly advised by lawyers who said, if you renounce your Pakistani citizenship, the Home Office, A, won't take your British citizenship off you, and B, won't be able to remove you to Pakistan because there are no direct flights to Pakistan ever since PIA got in trouble for.
So you know about that as well?
Others flying on them shortly before. Before it turned out a quarter of the pilots had been buying their licenses. So because there's no direct flights, then the Home Office can't just get a document and put the people on the plane. So, and because they've renounced their Pakistani citizenship, they've gained the system, and two of them, I think, in total, had racked up a £470,000 legal aid.
Oh my God!
Now,
Dreadful.
This is, I think, an instance where I think they deserve to lose their British citizenship and they deserve to be put on a plane.
Yeah.
Because there is nothing redeemable about these individuals that I can see. And I think that other migrants get tarred with the same brush. And not only migrants, other people get tarred with the same brush. Representatives and lawyers that represent migrants get tarred with the same brush. Yet nobody wins out of it. Some clever lawyers made a lot of money out of it, but it doesn't reflect well on the British system.
But there's a counterpart to that, isn't there? I mean, you don't want this person in your country, but that country doesn't want that person in the country also. What's good for the goose is good for the gander. I mean, if you don't want him because of his criminal convictions, why should the host country accept him back? Because of his criminal convictions.
That is the country of their birth. The United Kingdom was a country whereby they acquired citizenship as a result of their conduct. And someone's got to carry the can for them. They can go home. And I think the practical answer to this is that, and how it will pan out, is that the Pakistani government are trying to negotiate direct flights to from Pakistan to London. And so obviously this is, so I read involved in it, which is, well, if we have a flight from London to Islamabad, we'll just pop them on the plane. And I think that at some point they will be back in Islamabad.
And things will get moving. Okay. Now, this happens on a daily basis. You're walking through the tube station, or you're coming into a mall, and you've got the immigration service there. The police are there. They're stopping people. Random checks, immigration check, confirm your name, address, date of birth, status. What advice would you give to somebody if you're stopped by immigration?
If you're stopped by immigration, I can't say it's clearly enough. Be cooperative, tell them your details, but don't sign anything unless you have spoken to your lawyer. Ask to speak to your lawyer. If you're a migrant in the United Kingdom and you have a visa or you don't have a visa, my advice would be have an immigration lawyer that you can call. And do not sign anything until after you've spoken to your lawyer. You speak to me and say, I've been detained, stopped, or they're questioning me. I will ask the Home Office for a copy of all the documents. I will review the documents and I will tell you what you should do.
Moving on from there, I mean, the system's forever being manipulated by somebody or some new entering into the United Kingdom. Highly skilled migrants coming here to work under a COS. You've come here to work in a particular job at a particular establishment, and it turns out that immigration raid, and you're no longer a 5-star Michelin chef, you're making pizzas down the high road. What happens to your application?
Well, you're likely to have your visa curtailed on the basis that you are not doing the job that you entered the United Kingdom. Now, this is a tricky one because I had quite a lot of clients with this. And on a personal level, I have matters of sympathy for them. But when you come to the United Kingdom, if you arrive in the United Kingdom, you expect to be working in the Savoy, and instead you're being asked to work in a sandwich shop. If you start to make the sandwiches, then you are complicit in the dishonesty. What you ought to do, and I appreciate this is very difficult, is it would probably go home and speak to the agent and try and rectify it. Now, that might be artificial, it might be unrealistic. Alternatively, if you're in the United Kingdom and you don't believe you've been given the job that you are coming to do, you need to find another sponsor quickly. The best advice I can get is if you're here and it's not what you thought it was going to be, either find another sponsor or enjoy your time in the United Kingdom until the Home Office find you and then they remove you. Because a lot of people, I think, have abused this particularly.
Yeah.
I think what I would say is, and this may not get to that many people, if I'm in, say, and I've had clients from here, and I'm in, say, I can take the country, India, and someone says, I can get you a job in the United Kingdom. If they ask you for £30,000, for example, or £10,000 to do that job, if you pay that, then you are probably not coming to a real job.
Yeah.
You know that and you're prepared to commit criminal activity, you will get what is coming to you. If you're innocent and you think that we pay for jobs in the UK, we don't. I'm sure you've employed lots of people. If you said to someone that comes as a fantastic solicitor, you said, I'll give you a job, but you've got to pay me 20 grand.
No, of course not. Come on,
Wouldn't have many people.
No, of course not. I mean, just coming back at the point you said, if you're here as a highly skilled migrant and unfortunately your job isn't what it is, or alternatively the place closes down, my views as follows: either find an alternative sponsor or leave. The reason being is because you don't want to be deported.
It's either, as I said, if you get here and some people have cheated the system, they get whatever they deserve. Other people will have been cheated. If you're the victim of it, use the time you've got to find something, go home and take it up with the person that cheated you. Because the number of people that come to me that sit around and after the visa's been curtailed and they're here illegally and they come in and they're very upset. And they say, how can I stay in the United Kingdom? And I'm like, you can't.
Nobody wants to talk about it, especially in our field, but it does happen. The rogue practitioner. Okay. Now, as an ex-immigration lawyer, currently doing criminal defense, as a current immigration barrister, dealing with all aspects of work, by time and time again, get clients coming in saying, we haven't sorted out our status or our immigration applications, and for whatever reason, I've given £10,000, £15,000 to a practitioner, cash in hand, no receipts, no client account. I mean, I think the point I'm making is when you're choosing a practitioner, what should you look for?
At the moment, know what I say? I would, the internet can be your friend. Have a look online. See if the person has a web presence. If the person has a web presence, see if they are regulated by a body. I'm regulated by the VSB, I'm regulated by the SRA. There will be a reference number at the bottom. It means that you can check on the Bar Standards Board website whether I am a barrister, whether there's any issues with my practicing. So you can see. Look for reviews. See what other people say about me. See if I have an office. If I've only got a mobile phone number, that's probably a bit of a red flag. Do I have a physical office? What does the physical office look like? These are go and see the person, talk to them. These are the types of things that I would ask. It's common. Things not to do. Don't go to a friend who knows something about immigration law, who's helped everybody else out. You might have people in your own community and they go, he's helped everybody out. And this is where it comes right back to what we started with at the beginning. I may not speak the language of my clients, but I will tell them the truth. Sometimes, and I can understand this, clients have come to me and they said, well, I went to see Mr. X. And I say, is it because he speaks your language? Is he from your community? The fact that somebody is from your country doesn't necessarily make them a genuine lawyer. It doesn't make them a rogue lawyer. They just come from the same country as you and they speak the same language. Might make it a bit easier. You can still do checks on them. Don't use a friend who knows a bit about immigration. Don't go to somebody who everybody says is great and just because he speaks the same language. And don't hand over large amounts of cash to people without receipt, because that's probably it could be the last you ever see of it.
Okay, right. On a final note, thank you very much for coming in. We wish you all the best at Imperium Chambers. I mean, I've got to say for the viewers, I mean, as an immigration barrister on TikTok, I think you're certainly making moves. I mean, you've got a very big audience, and I think, well, do you think it was worth it?
Yes, I do. Actually, I started off doing it. The more I do it, the more I enjoy it. It gives me a chance to talk directly to people.
Yeah.
Clients are people, and I could lecture people from the books that nobody's really interested.
Yeah.
Hopefully I make it interesting.
Thank you very much. Thank you for having us.
Thank you.
All right.